So welcome everyone to week 8 of our unit in LAWS12061 and Administrative Law. And tonight we talk about natural justice. And I'd like to welcome all of you who are here tonight at this tutorial. And I welcome as well all the others who will be joining us later on. Please note that I have muted everyone, and in the event you need to say something, you're going to have to turn on the mic on your own, and as well, you can also say something by putting in something in the chat box, and I think you'd also raise your hand in Zoom. So tonight we talk about natural justice, which is a crucial topic because every time an administrative decision is made, and that administrative decision affects us in various ways, we often wonder if, number one, do we need to have been given an opportunity to be heard before a decision was made? And related to that is the question of whether or not a decision maker actually has a duty to provide us any reason, for the decision to be made. And when we say a duty to provide reasons, like at the moment after a decision has been made, can we ask the decision maker as a matter of law to provide us a reason for the decision? And in the event that the person fails to provide the reasons, then it might be said that we might have options, let's say for judicial review, to compel the decision maker to provide us reasons under, for example, under Section 13 of the Administrative Decisions Judicial Review Act of 1977 Commonwealth. So that's one aspect. It's called the prior hearing rule, which is the audi alteram parte, here the other side. And it's a crucial point because, many decisions can be made. It could be, meaning many executive decisions are often made. It could be in relation to a job application. It could be with a Commonwealth agency. It could be an application for promotion. It could be that somebody has been terminated from a job. It could be that, somebody had a business license. The business license was canceled. It could be that somebody is applying for registration, and a decision is made whether to grant the registration or not. And in those cases, you begin to wonder, before a decision was made which could have been adverse to you, would there have been a requirement on the part of the decision maker to provide you an opportunity to contest, or to provide? How come the Zoom is like this? Hang on, what's going on? Would there have been a requirement? It seems strange. Something wrong with the sharing there. Give me a second. Something was wrong with the way I shared the screen. Not sure what happened. It seems better. And you want to know, would there have been a requirement for a person for the decision maker to have provided your reasons? It can also apply in relation, for example, to visa applications. So somebody wants to apply for a visa to enter into Australia. It could be for a visitor visa. It could even be for a permanent visa. It could be for a work visa. And in those particular instances, the question is, before a decision is made, would there have been a requirement as a matter of law for the executive decision maker to give you an opportunity to contest any adverse facts that might be in the possession of the decision maker? And if a decision is eventually made, and assuming that the reasons for the decision were not given, meaning a decision was just given without explaining the reasons for the decision, would, as a matter of law, a person affected by a decision have the right to demand reasons from the decision maker for the decision? So that's one aspect. And so we know, there have been many instances when the executive will make decisions. It could also be in relation to, rates, could be taxes and so on. Would there be decisions to request for reasons, or would there be a duty on the part of the executive to observe the rules of natural justice? So that's one aspect. The other aspect is the rule against bias. In Latin, it's nemo debet essex judex in presua sub causa. So there is a requirement that no person should be a judge of his own case, and a person should act fairly. And that can be important because, it's possible that somebody who eventually will make a decision on something before the decision maker, an application, for example, maybe something you know, maybe someone you know, and that somebody that you know happens to be somebody who dislikes you, or you probably had a tiff with that person at some point. It could also be that you know that that person has made statements in the past, has behaved in ways in the past that you know will mean that that decision maker is likely to act unfavorably against you. So in those cases, would there be a breach of the duty of natural justice if the decision maker continued to make a decision? So tonight, this is what we talk about, the topic on natural justice. And after studying this topic, you should be able to discuss and explain the principle of natural justice and when it applies. You should also be able to discuss and explain the hearing rule and the rule against bias. Now, before we continue, would any of you happen to have any questions? In relation to the midterm assessment, I finished the marking, but I will only release the results by tomorrow noon. So I'm just going to do one final review. If you notice, it's stated in the unit profile that the results were going to be released tomorrow, mainly because there's a lot of marking to be done. I probably marked over 200 papers over the Christmas break. So there wasn't much of a Christmas break for me, because not only am I marking midterm assessments for LAWS12061, I'm also marking papers for public, international, and human rights law. So there was a lot of marking to be done, and it's not just simply a question of putting in marks. You have to provide feedback as well. But tomorrow you should get the results. I will release the results by tomorrow noon. Okay. So before I continue, any questions or comments? So we're good. Now, please remember that as far as the video is concerned, I don't really see all the phases. I only see 1, 2, 3, 4, 5, I think. 5 of you on my screen. So if some of you actually, raise your hand or, make funny faces, I'm not going to see you unless you're one of those among the 5 that appear on my screen. So just a note so that in case you want to say something, you're going to have to unmute yourself or write something in the chat box. Okay. So having said that, there seem to be no questions nor any comments. We're going to go through 5 discussion question topics tonight, just for us to be able to examine in greater detail the concept of natural justice. Okay. It's always good to be seeing faces, actually. So I'm glad that some of you, turn on your videos. So let's begin. We're going to go through the quiz first. And then, we'll go through 4 other discussion questions. Can I ask someone to please read the quiz question for us? Just to read the question. Can I get somebody to do that? Just to read the question. Sarah Rogers.
I'm happy to do it if nobody else
Good.
Thank you. Gail Ashgrove decided to pursue a master's in political studies at an Australian university and applied for a scholarship under the Research Development Scholarship, RDS Act, Commonwealth, the Act, administered by the Australian Department of Education. The Act provides that research development scholarships shall be awarded on the basis of academic merit. It also provides that the Minister of Education, the Minister, shall head the RDS Selection Committee. Having graduated with first-class honours from the University of New South Wales, Gail was confident that she would get a research development scholarship. However, she had some apprehension about getting a scholarship because the Minister had shown during a TV interview a bias against students who protested against the visit of the Chinese Premier in Canberra, during which a major student disturbance had taken place. Gail had led the student protests during the Chinese Premier's visit and had even engaged in a heated shouting match with the Minister at that time. Gail subsequently received a brief letter informing her that her scholarship application had been unsuccessful. No reason was provided for the rejection of her scholarship application. Gail has come to you as solicitor for advice. Instructions: do not read the Research Development RDS Act Commonwealth, and limit yourself to the above facts and the relevant administrative law statutes and legal principles. Which of the following statements is the most correct? Select one. Gail's right to natural justice has been breached. She should have been given an opportunity to explain her role in the student protests prior to her scholarship application being rejected. B. Gail's right to natural justice has been breached. The minister showed a bias against her. C. As part of her right to natural justice, Gail has the right to demand reasons from the minister for the rejection of her scholarship application. D. Gail has no right to demand reasons from the minister for the rejection of her scholarship application. Or E. Gail's right to natural justice was breached by the failure of the letter to provide reasons for the rejection of her scholarship application.
Okay. So, was there something that, do you have D there among the answers? Did you get to read this, Sarah? You did?
Yes, we did, yeah.
Okay, very good.
Oh, sorry, did I read that? Yeah, I did. Sorry. Hopefully I didn't miss that. I do apologise, everyone, if I did, sorry.
Okay.
Gail has the right to demand reasons as well.
Very good. So can I ask everyone, looking at the screen now, can I ask everyone to, post your answer in the chat box from letter A's to E? So you've got A, D, E, C. Most are answering C. So some are answering D, some are answering A. Has there been a B answer there? Okay, so it's essential A, C, D, and E. All sorts of answers. Interesting. We don't often get that. Okay.
I don't know about anyone else, but I found this quite a difficult one, and I kept flitting between all the different answers. Normally, I pick one and go, right, okay, I feel comfortable with that. This week, I was like, oh, I don't know. And the more I read, the more confused I got. So I'm glad that everyone else is in the same boat, it looks like.
Okay. So can I say they are structurally the same? Let's see at C, the right to demand reasons. So C and E are different because, although they appear the same, because as far as C is written, it appears like, does Gail have the right to demand reasons after the scholarship letter has been the letter has been received by Gail? So in other words, following Section 13 of the ADJR Act, where under that particular provision, when a decision has been made and a person is entitled to make an application to the federal court under Section 5 of the ADJR Act, then that person may request for, by notice in writing, to be given to the person who made the decision, requesting for reasons for the decision, as well as asking the person who made the decision to set out the findings of fact and so on under Section 13. So as far as C is concerned, it's different because the idea is you demand the reasons after the rejection has been given under following Section 13. E, on the other hand, is that every time a decision is made, then the understanding is that the decision maker ought to have provided reasons in the decision itself. Okay, so that's the distinction there. B, okay, so finally we've got answers from A, B, C, D, and E because Lindsay answers B. Okay, so okay. So where do we begin? Can I get somebody to try to explain the reasons? I mean, your answer, whether it's A, B, C, D, or E. And then I'll explain, I'll give my views later on. Can I get somebody to explain A, then B, then C, then D, and E?
I selected D because because this isn't in relation to a right, interest, or legitimate expectation. For a future, well, it's not even for a right or it's an interest or a future legitimate expectation, and that's why I chose D.
Very good, fantastic. I got that. I'm not gonna comment yet. You're gonna, put it in suspense. Okay. Thank you, Kayla. And you're gonna know the answer in a short while, at least my view. Okay, and then you can disagree with me. Then we can talk about it. Anyone giving an A as an answer? Can you try to explain why it is A? Sarah Rogers says it's A.
Yeah, I flitted between that and the other one. And my reason for the other one was the fact that there's a case that the minister, and Gia, I think it is, that said that ministers don't have to have the same legitimate expectations. But I went with A because the statute, common law duty of natural justice applies unless there's an express statutory intention excluding it. So I thought because she hasn't been given this reason, the reasons or the opportunity to produce her case, that in that case, that her natural justice rights have been breached.
Interesting. Can I ask a question, Sarah, if it's all right? Are you suggesting that in the event a decision is made by an executive decision maker, then in all instances, it will necessarily attract the duty to accord natural justice? Is that what you're saying? Simply because a decision has been made, then that will attract the duty to accord natural justice. Or is there a requirement there?
I think that according to the common law, as far as I read it, that we have, where there's a legitimate right or expectation, then we have the right to natural justice. But as Kayla was saying, that perhaps in this occasion, because it's an application for a license, it's not a renewal, or it's not, she doesn't have a right yet. So that was my potential confusion there.
Very good. So I think we can generally agree that as a matter of law, when you speak of the principle of the right to natural justice, the right to natural justice can only arise when a person's rights, interests, status, or legitimate expectation can potentially be affected by an executive decision. So in other words, when a person does not have a right, when a person has no interest, has no status, or legitimate expectation concerning an executive decision, then the right to natural justice is not attracted. Okay, now, so the moment that a person's rights or interests or status or legitimate expectation can potentially be affected by a decision, then the rule is that according to the principle of natural justice, that person must be accorded an opportunity to be heard, unless it could be understood from some statutory provision that the right to natural justice has been excluded. Okay, okay, and so from Keith as well, there are certain decisions that affect a class of persons. So there are certain decisions that affect a class of persons. It could be, taxes, it could be rates, it could be, central benefits that affect everyone. Then in that case, again, even if you might say that, I was getting, you might say that I used to get $3,000 in family tax benefits, but because of a change in the regulations of the executive, based on subordinate legislation, that, the executive, the minister did not even give me an opportunity to be heard why my family tax benefits shouldn't be reduced. That will not attract the right to natural justice, as correctly pointed out by Keith, because it affects a class of persons and not an individual in terms of its individual rights, interests, or legitimate expectations. So as far as A is concerned, the basic question is, the basic issue for us is Gail's right to natural justice would only be breached if she had a right to the scholarship, or she could claim that she had a legitimate expectation to get the scholarship. She can't have an interest in the scholarship, but does she have a right or legitimate expectation? It can't be a right. She was simply applying for it. Could she have a legitimate expectation? It's difficult because there are so many applicants. How can you legitimately expect that you're the one who will be accorded the scholarship? So in that particular case, we could probably strike out A. Okay, so we're left with B, C, D, and E. Any objections to what I have offered? That, A is probably not the correct answer. So we're in agreement there? Okay, so we're going to go back to C in a short while. Okay, so from Lindsay, in terms of A, as a matter of human rights, political interests, or otherwise, supersedes, she has no obligation to prove her point, and therefore this has no basis for the decision. Okay. Thank you, Lindsay. Now, B. Gail's right to natural justice has been reached, and the reason for this is that the minister showed a bias against her, because we know this from the facts that there had been a previous certification. Yes, Nicholas? Nicholas, did you want to say something?
No, I can't. Oh, there we go. I couldn't get my mic to work. I was just playing around. I was trying to get the point under point A as well, is that she's part of a class of people that were applying for a particular grant. So there's no guarantee she would have got it anyway.
That's right. That's right. Very good. Now, did the minister show a bias against her simply because there had been an altercation at some point when she engaged in a heated shouting match with the minister? Would that necessarily mean that there's a bias? No. I mean,
I would say no, Manjo. And the second thing is she'd have to prove it before you could go to DJR anyway.
True. Very good. So B is probably not an answer, because there's nothing to indicate for the facts that there has been a bias. Just because they fought at some point, they had an argument, would not mean that there is a bias against her. Okay. Now C. As part of her right to natural justice, Gail has the right to demand reasons from the minister for the rejection of her scholarship application. The idea here, and we're trying to distinguish C from E, is that after Gail received the notice rejecting, informing her that her application had been successful, could Gail then go back to the minister and citing Section 13(1) of the ADJR Act, could Gail then demand reasons from the minister for the rejection of her scholarship application? That's the nature of letter C. What do you think?
Yeah, I believe she can, Manjo, because in simple terms, she's received a letter with no explanation as to why, and under natural justice, unless the Act specifically excluded it, she has a right to know why.
Okay. Let's examine that statement there, because as Nicholas said, under the right to natural justice, then she has, a right to get the reasons. But we know that the right to natural justice can only be attracted if a person has a right, an interest, or a legitimate expectation. So are we saying that even if a person has no right, has no interest, or has no legitimate expectation, can we say then that Section 13 is necessarily triggered, so that every time an executive decision is made, a person is entitled to reasons for the decision? So imagine the circumstance of a visa application, applying for a tourist visa. And let's assume that the Immigration Act is silent as to whether or not the executive has to provide reasons. And let's assume that there was a short letter informing the person that the application has been denied. Can we say that that person can then seek recourse under Section 13 because the decision was made under an enactment? Can it then be said that the person cannot demand reasons for a decision? And you can apply it in many circumstances. It could be, applying for a business license. It could be applying for particular benefits for the first time. And does it mean that every single instance you then have a right to, to demand reasons for the decisions made by the executive? What do you think?
Not in every instance, Manjo. It depends. I mean, if you've got somebody that's applying for an immigration visa, then they're not an Australian citizen. The Constitution comes into play for a start. The second thing is if they're being deported, as an example, the minister wouldn't have to tell them that they were going to be deported under the guise that they may do a run or a hide and avoid justice that way. So there are times when you wouldn't, but in this case, I still think she could.
Yeah, okay, very good. There's a point here made by Michael. So let's say 2,000 people apply and 1,999 people want a reason why they didn't get it. It could mean the minister is busy. So can you imagine, looking at it from that perspective, and it's not just 2,000, it could be 200,000, it could be 2 million. Can you imagine that the minister is required to, and it's not just a single decision, can you imagine the number of decisions the executive has to make every single day, right? There'll be multiple decisions from a single agency. Imagine if every time a decision is made, reasons have to be provided, there will be no end. So let's begin. There'll be three answers. There'll be three reasons for my answer. Number one, as a matter of law, as a matter of common law, there is no requirement for the executive to provide reasons for a decision. As a matter of common law, okay? That's basic in Kiowa versus West. There is no requirement on the part of the executive to provide reasons for a decision. So that is as a matter of law. Now, we do have Section 13 of the ADJR Act, which says that when a person makes a decision to which the section applies, any person who is entitled to make an application to the Federal Court or the Federal Circuit Court of Australia under Section 5 may ask for the decision maker to give reasons for the decision. But the provision there is, it says who is entitled to make an application under Section 5. Now, if you look at Section 5, it's not simply triggered by the fact that you have a person has been aggrieved by a decision. Section 5 also provides that there has to be a ground for the application. Okay, so you only trigger Section 5 under the ADJR Act if you actually have a ground for an application for judicial review under the ADJR Act. Okay, so to my mind, the third reason is, if you follow the case of Public Service Board of New South Wales versus Osmond, which involved a case of Osmond applying for promotion under the Public Service Act of New South Wales. His application for promotion had been denied. No reason was cited for the denial of his application for promotion. He felt he should have gotten it. And then he sent a letter to the Public Service Board asking for the Public Service Board to provide reasons for the denial of the application for promotion. And the High Court ruled in Public Service Board versus New South Wales versus Osmond that there was no requirement that there was no right on the part of Osmond actually to demand reasons for the decision of the Public Service Board. So what it means is that, and this is my reading, I haven't really come across case law on this, and the closest one really is Public Service Board versus Osmond, which seems to be the closest we can get, and it's actually in the last chapter of our prescribed textbook. As a general rule, if you follow Section 13, Paragraph 1 of the Administrative Decisions Judicial Review Act of 1977 Commonwealth, that section, which gives an aggrieved person a right to demand reasons for a decision, will only be triggered under Section 5 of the same Act if that person has grounds to apply for judicial review. And the grounds could be the breach of the rules of natural justice, or the fact that the decision was made without evidence, and so on, or that the decision involved an error of law. So in the absence of a right on the part of a person to apply for judicial review under Section 5, Section 13 cannot be triggered, because Section 13 provides that a person must be entitled to make an application under Section 5. And if you apply, the idea that you look at efficiency of government, as pointed out by Michael, can you imagine if every single person who has been affected by a decision will always have a right to demand reasons, even if the person doesn't have any right or interest or legitimate expectation? That would be too onerous, in the words of Michael, on the part of the government. So to me, C is not the correct answer for the reasons I cited. Any countervailing view? I mean, if you're against it, you're gonna have to tell me your reasons. I've given you mine. I've given you 3 reasons for it. So to me, therefore, D is the correct answer, as pointed out by Kayla earlier. It's letter D. So Gail has no right to demand reasons from the minister for the rejection of her scholarship application, because Section 13 of the ADJR Act can only be triggered when a person actually is able to apply for judicial review under Section 5, based on one of the grounds cited in Section 5. Okay? So E cannot be the correct answer as well, because as we said, as a matter of law, as a postulate of law, there is no requirement on the part of the executive to provide reasons for executive decisions. As a matter of law, no requirement whatsoever, unless the law provides that decisions must be given. So the way things stand, the executive can make a decision. There is no requirement on the part of the executive to provide reasons for the decision. Are we clear?
So let me just clarify that. If this particular act we're talking about, this research development scholarship, said that any decision made must be provided to the applicant, for or against, and the minister failed to provide one, would then that be an error of law that would allow for her to take it to through the process?
Yes. So under the facts that, in the example you gave, Nicholas, you had said that the enactment itself said that, any decision, any person who would have been affected by a decision should have been given reasons or a reason for the decision. In that case, the right to natural justice will arise. The decision maker will then have a duty to provide reasons for the decision. From
yes. What is the reason then, Manjo? Is the reason that it's an error in law that the reason wasn't provided in the written letter?
Okay, that's a crucial point. We're discussing this, I think, in week 9. The concept of error of law is actually pretty broad. Okay, so error of law can mean an error in terms of the application of the law, an error in terms of interpreting the law. The breach of natural justice is also an error of law, as we later see. Wensby and reasonableness is also an example of error of law. So as a broad concept, a lot of these specific reasons for the availability of judicial review can actually be covered under the principle of error of law. Now, the reason why error of law appears as a distinct category, and I think we're seeing this in week 10 on judicial review remedies, is that when it comes to certiorari, and we're jumping the gun a bit too much, the rule is that if you apply for the writ of certiorari, meaning you want to have a decision of the executive to be reviewed, then the error of law must appear on the face of the record. So in other words, you cannot rely on evidence before the court. It has to be on the decision, on any document transmitted to the court. So that's why you have that, okay? But error of law is a broad term. So if you look at week 10 later on concerning judicial review remedies, the error of law must appear on the face of the record. But again, it's a broad term. So it means that the reviewing court, the appellate court, when it looks at the records of the case transmitted to it from a lower court, it will be evident what the error of law is. Now, when it comes to factual circumstances, therefore, meaning there's a dispute as to what happened, somebody said this, somebody said that, it's therefore evidentiary. That won't be evident on the face of the record, because that's not in the records of the case. But still, as I pointed out, error of law is actually a broad term. Okay, and so the failure to abide by the principles of natural justice involves an error of law, but it won't be, But in terms of the writ of certiorari, it won't trigger that, because the requirement of a writ of certiorari is that it must appear on the record of the face of the record. Okay. Very good. Questions so far before we continue? It's clear now. The other point I need to clarify is that, so we now know that as a matter of law, there is a requirement on the part of an executive to provide reasons for a decision as a matter of law. Are we clear about that? Now, we know, however, that when a decision is made based on an enactment and a person's right or interest or legitimate expectation has been affected by an executive decision, although the executive decision maker does not have to provide a reason for the decision at the time that the decision is made, under Section 13 of the ADGR Act, the person who is affected by a decision can request the decision maker to provide reasons for the decision. That's assuming that that person, the aggrieved person, can cite one of the reasons under Section 5 why judicial review is available under the ADGR Act. Are we clear so far? Now, but what it also means is that if an executive decision is not based on an enactment, So remember, we talked about the implied executive powers. We talked about prerogative powers. So there are certain inherent powers of the executive, not based on statute. So if the executive exercises non-statutory executive powers, or powers which are not based on an enactment, then Section 13 cannot be triggered. So in those instances, when the executive decision is not based on an enactment, one, the executive does not have to provide reasons, and secondly, the executive cannot be compelled to provide reasons for the decision at all. Okay, clear? Okay, very good. Let's go to problem 1 then. Can somebody read problem 1 for us, please? Nicholas, can you do it for us?
I think I can, Manjo. All right. The Business Regulations and Control Act Commonwealth requires that before a person or persons may engage in business or a commercial activity, prior registration must be secured from the Australian Business Regulatory Agency. The Act provides that the agency has the power to shut down a busy or commercial activity that operates without being registered with it. In addition, the agency may also seize documents, papers, goods, properties, and assets belonging to an unregistered business and impose a fine. The Act is silent on whether prior notice must be given by the agency before seizing the documents, papers, goods, properties, and assets belonging to an unregistered business. Aaron Lamb has been operating a small business for some time by selling his handmade goods to customers online. However, he failed to register with the Australian Business Regulatory Agency. In February, representatives of the Australian Business Regulatory Agency came to his house without notice and seized his goods, documents, and papers. They informed Lamb that his goods, documents, and papers would only be returned after he had paid a fine of $10,000. Lamb has come to you as a solicitor for advice. Advise Lamb on the validity or invalidity of the actions of the agency.
Thank you, Nicholas. What do you think? Thank you, Nicholas. So do you think that the actions of the agency are valid or invalid? The actions of the agency in terms of seizing the documents, goods, and papers of Lamb, were those actions of the agency valid or not valid? Can I just get people to provide your answer in the chat box? Valid or not valid? Very good from Nicholas, not valid. What do the others think? Okay, not valid. Very good. Okay, so the answer is not valid. Why not? Why isn't it valid for the agency to have seized the goods, documents, and papers? Note, there is a law that says that anyone who operates a small business must have a license. Now, obviously, Lamb does not have a license. So because Lamb was actually in violation of the law because he did not have a license, couldn't it be said then that it was a violation of the right to Lamb's Lamb's right to natural justice? There was a right on the part. Lamb did not have a right to natural justice because he did not have any license in the first place, in violation of the law. Why would it say that there was a breach of natural justice? Let me repeat that. Just to clarify, again, we said, based on the facts, Lamb did not have any business license. He did not have any registration. So he was operating in violation of the law. Correct? So because he was violating in operation, he was operating his business without a license in violation of the law, why wasn't it permissible or valid for the agency to seize Lamb's goods, documents, and papers? Why would there be a breach of natural justice? Why would there be why would the hearing rule be triggered? Can somebody explain that to me? Or could it actually be said that the actions of the agency were valid?
Manjo, I actually said that the actions were valid because I felt that he didn't have a right. He wasn't a registered business. I felt that despite entering Carrington that says you have a right to property and stuff, because his actions were not valid and because there was express statutory authorization to seize documents, papers, goods and properties, that actually the agency were acting within their rights to do such a thing.
Interesting. What do the others think?
No, I still think it's invalid. I still think even if the words of a statute, in this case in a literal sense, as in Cooper and the Board of Works, any qualification at all, it still doesn't create a justification for the government in this case to take hold of all his assets because they're personal assets.
Okay. I need to clarify, when I ask questions, which might be called probing questions, it's not so much because I actually have a view. I'm actually just trying to trigger a discussion here, okay? So I would agree with Nicholas. If you look at the case of Cooper versus Board of Works for the Wandsworth District, in that particular case, the property of Cooper was destroyed by the Board of Works because it was in violation of the law. He did not have a license for the property. And yet, the court pointed out that there are certain property rights observed under common law. So, and we saw this from Antic versus Carrington. You know, there's a right to property. There's a right against trespass. It is a common law right. It is not a right which is required by statute. The courts recognize that people have rights to property. And so in the case of Cooper versus Board of Works for the Wandsworth District, even if it might be said that there was a violation of the law because Cooper did not have the proper permit, but there could have been an innocent explanation why at that time he did not have a permit. For all we know, there might have been a permit. Wouldn't you say? There could have been some administrative error there. Although all along, you know, Lamb, for example, may have assumed that he had the proper permit, or he wasn't required to. And the question that the court asked was, what danger is there in providing a person the opportunity to be heard? Nothing. So in that particular case, the right to natural justice would be attracted. So the answer here is that if I were the solicitor, I would advise Lamb, following what Nicholas has said and most of you had said, that he should apply for judicial review under the ADGR Act because his right to natural justice had been breached. He had the right to his property. I mean, for all we know, the goods, documents, and papers had nothing to do with the business. It could have been used for studies. It could have been used for something else. It could have been his private papers. So in this case, there is a following, Cooper versus Board of Works for the Wandsworth District, Jarrett versus Commissioner of Police, following Keogh versus West. There is a right to natural justice, mainly because Lamb would have a right to property. Goods, documents, and papers are property, and they attract the right to natural justice. Very good, Nicholas. Thank you. So we're clear. So in that case, the advice should be for Lamb to apply for judicial review because his right to natural justice was breached. Let me just change the facts a bit. Now, what had happened was that when agents of the agency, let's assume that they brought in the Commonwealth, the federal police, they saw that what were there would be illegal drugs, ecstasy pills, if you could identify them, or firearms. Okay, so I said illegal drugs, firearms, and explosives. Question: would the right to natural justice be triggered by in that new example I gave, so that before the firearms, before the illegal drugs, before the explosives could be seized by the federal police, that person should have been given an opportunity to be heard? What do you think?
No, they don't need to be told because it's already in the legislation that those particular items or having controlled substances against the law and by informing these people that the federal police were coming to take them, they could remove them and hide them. Other words, break the law again and continue the process. So they don't need to tell them they're coming to do it.
Very good. So that's the correct answer there. In the new example I gave, when we speak of illegal drugs, firearms, and explosives, by law, by definition, these are illegal. You can't say that you have a right to illegal drugs. There's no such thing. Okay, so by definition, by law, these are meant to be prohibited, and so therefore they're subject to seizure. You don't have a right to them. Secondly, as Nicholas pointed out, there are instances when, if you have to provide, and this is cited in KO versus West, there are instances when you cannot provide a person an opportunity to be heard because that will give a person an opportunity to violate the law. It could be like, if it were a visa application, somebody may just take off and you can't find the person anymore. Or in the case of illegal drugs, as pointed out by Nicholas, it will give the person an opportunity to hide them. So there will be instances when there are exceptions to the rule on the right to natural justice when it may arise.
But surely that would be in the gaining of a warrant, not in the actual entry of the premises.
Okay. So the question for you, Keith, is whether or not there would have been a requirement for a judicial warrant. Is that a question?
Yes. Yes, that's a question. That decision is the one that is not challengeable, because if there's reasonable cause for a warrant, then you obviously don't tell the person, hey, Joe, I've got a warrant to your place, so I'm going to come and bust the door down.
Okay. We're going to go into constitutional law. So I'm going to make that as a question here. And the question is, does it require the courts, is it a requirement that it can only be courts that can issue orders for items to be seized? Or can the executive have the power to seize items even in the absence of a judicial warrant? If you look at, if it is a matter of constitutional law, the answer is that there is no requirement that it has to be judges belonging to Chapter 3 courts that have the power to order the seizure of items. The executive can do that. The judicial power will only be triggered when there is an actual controversy between persons or between individuals. At the point of the seizure of an item, there is still no actual controversy. There is no actual controversy at that point. It's simply an executive decision that is made. So you will notice, therefore, that in many cases, the law will simply provide that the executive has the power to seize items. You can see this happening in customs. You can see this happening in the exercise of police. When they see contraband, they just seize it. So there is no requirement that it can only be the courts. And in fact, even when the courts are the ones who provide what might be called judicial warrants, what had happened actually is that in those instances, the courts are not actually functioning in their judicial capacity. But we're talking about constitutional law now. This is an exception to the rule because if you look at the Boilermaker's case in constitutional law, there are two requirements there. One is that judicial power can only be exercised by Chapter 3 courts. But the second rule there is that judicial power cannot be exercised by non-Chapter 3 courts or non-Chapter 3 officials. So the ability to issue seizure orders is not does not involve a matter. It doesn't involve a controversy. So you do not require an exercise of judicial power there. And even when the judges do so, it's actually on the provision of the persona designata rule. Under the persona designata rule, it means that when judges exercise certain non-judicial functions, because it is a non-judicial function, when a judge issues these warrants to seize items, it is a non-judicial function. It would have been a violation of the Boilermaker's case. But under the persona designata doctrine, the judges are permitted if, number one, they agree, they consent to the designation for them to undertake non-judicial functions because it is non-judicial, but at the same time, it is not incompatible with the functions as judges. In other words, one, they're not really under the direct supervision and control of the executive. So they're not just working under the behest of the executive, but they can act independently. And secondly, the other requirement is that by doing so, by acting under the persona designated doctrine, these judges do not put the judiciary in disrepute. Okay. Questions, comments? Okay. Very good. So let's go to problem. Thank you for raising that, Keith. Very good for raising that question. Can I get somebody to read problem 2? Problem 2.
Can't see it on the screen yet, Manjo. It's still on problem.
There's a little delay. Okay, that's fine. Is it coming up? Okay. So can I get somebody to read problem 2 for us? Volunteer?
I'll volunteer if no one else steps in.
Thank you, Keith. Thank you. Go on.
During a TV interview with James Colt for the televised Colt Report, Minister for Immigration and Border Protection, in inverted commas and brackets, the Minister, Scott Tomlinson, said, "As the Minister for Immigration and Border Protection, I have very strong reservations about people applying for Australian resident visas who claim to have an epiphany and claim to be good and honourable men despite having committed serious crimes and atrocities in the past as jihadi fighters abroad. These people are heavily radicalised by their war experiences and pose a potential danger to our community, even if they may appear respectable today by running a string of businesses in Sydney or elsewhere." About a month after the TV interview, Omar Owaldi, who owns a profitable chain of laundromats in Sydney, received a letter from a delegate of the minister informing him that his application for an Australian permanent visa had been denied on account of evidence that he had committed serious crimes and atrocities in the past as a jihadi fighter abroad. The letter stated further that notwithstanding the character references and evidence presented by Owaldi that he was a changed man, the minister was of the view that Owaldi is an excluded person under the Migration Act 1958 Commonwealth, full stop. Owaldi has come to you for advice as a solicitor and believes that the minister was biased against him. Advise Owaldi if the minister's decision may have been affected by an actual bias as shown by his TV statements and whether they may have been a breach of natural justice.
Thank you, Keith. So can I get, again, all of you to post your answer in the chat box? Was there a breach of natural justice or not? So the legal issue is, did the actions of the minister show an actual bias that would then indicate that there was a breach of natural justice? So was there a breach of natural justice or not? Okay. Some say yes, some say no. So if you were going to be the solicitor, what would you advise? Because if you advise wrongly, it's going to be costly for the for your client, and potentially the client can sue you later on for providing the wrong legal advice. What do you think? And we're just focusing on the principle against the no bias rule. We're not looking at the prior hearing rule. We just assume that there was no breach of the prior hearing rule. We're looking just at the issue of the no bias rule. So many say yes, many say no. Can I get somebody to provide your reasoning for your answer?
Well, Manjo, I've said yes because it's pretty clear that the minister had very strong reservations about all the people, and it was broadcast Australia-wide. This is not something that was just done locally. This is something that was put out to the entire public, and it was done by the minister himself for immigration. That stands to show bias directly.
Mm-hmm. Very good. What did the others say? We've got a number of students saying, no, there was no breach of natural justice. What do those who say no say? How do you explain your answer?
That you can have a preformed opinion, Minister for Immigration and Multicultural Affairs versus GIA, sorry.
Good.
And while you may have that preformed opinion, it only becomes biased when it's shown that you will not change your mind upon a reasoned argument.
Very good. That's the correct answer there from Keith. The answer is, no, there would have been no breach of natural justice following the case of Minister for Immigration and Multicultural Affairs versus GIA. And in fact, in that particular case, the court recognized that ministers, being political animals, are often required to announce certain national policies and political statements for whatever reasons. One, to state national policy, or two, it could be to curry votes. But the mere fact alone that they seem to have a predisposition of mind will not mean that there is an actual bias, as correctly pointed out by Keith. There will only be an actual bias if such predisposition of mind is incapable of being changed, notwithstanding the evidence that would appear before them. But the mere fact that statements are made is not indicative of actual bias. That would then mean that there is a potential violation of the no bias rule. So the answer here is, pointed out by Keith correctly, there is no breach of natural justice following the case of Minister for Immigration and Multicultural Affairs versus GIA. Questions? Very good.
One quick question, Manjo. Yes. Prove the case that there is no bias by the minister when the minister has made these statements and then subsequently followed through with that statement and prevented this guy from having a permanent visa. I mean, it stands to reason that his statements are biased and then his actions are followed by those biased statements.
I agree, Nicholas. There appears to be a bias on the part of the minister. Very, very strong bias, in fact. But it is not bias alone that would then mean that there's a potential breach of natural justice. It has to be a disqualifying bias. Okay, so somebody can have a bias, fine. But that bias will only disqualify an executive if the bias is such that it is incapable of being changed, notwithstanding evidence. But if it is just a predisposition of mind, somebody's inclined to do this or inclined to do that, that's natural. Everybody has a predisposition somehow, even judges do. But the question is, despite that predisposition of mind, and you can speak of members of the jury, there's always a predisposition of mind. But the only question is that predisposition of mind subject to change if you come across evidence that will either support or go against your initial views? So it's not the presence of bias per se, it is disqualifying bias that we are speaking of. Okay, so final question. Thank you for raising that, Nicholas. Very good, because it's always important for us to be able to examine in detail these. Okay, Michael, see you soon. Thanks. So final question. Can I just read this? Anyway, the point is we're running out of time. I think some of you are going to be leaving the session straight away. The question, essentially, I'm going to state the question as such as Clemshaw applied for, it had an existing business license. It applied for its business license to be renewed. Its application for business license, for the renewal of its business license, was denied. Okay, without giving Clemshaw an opportunity to provide reasons for the possibility of a denial. So it was not given an opportunity to be heard when it applied for renewal before the application for renewal was declined. The question is, was there a breach of the rules of natural justice by the failure of the agency to provide Clemshaw an opportunity to be heard before denying its application for renewal of business license? That's a legal issue. Sarah?
Yeah, I think this is distinguishable from the first question we were talking about, because in this case, because there has been an existing business license, this person does have a right to expect that and the circumstances haven't changed. I think there's an immigration case where there's a renewal of a visa and the situation hasn't changed. In that circumstance, there could be a breach of natural justice, because without the opportunity to provide reasons, then that person has a legitimate expectation as well as a right to be able to put their case forward.
That's the correct answer. Thank you, Sarah. Because it is a renewal. And the example that Sarah perfectly gave was the one with a visa. If you have an existing visa, you have a legitimate expectation that in the ordinary course of things, when you apply for a renewal, you will be given a renewal. Okay, see you soon, Kayla. Okay, thank you. So the rule here is, because it's a renewal, there will be a breach of natural justice if that company is not given an opportunity to be heard. But had it been an application for a new license, a license for the first time, the rules of natural justice will not be attractive. But because this is a renewal, the rules of natural justice will apply. The particular case is actually FAI Insurance Limited versus Winiki. So there is a court ruling on this. When it comes to renewal, there is a legitimate expectation that the license will be granted again. So the rules of natural justice must be followed. Same thing with Kiowa versus West. Okay, 7:01, a lot of people are dropping out. Any questions before we end tonight's session?
No question. Just a statement, Manjo. So far tonight, I've been 50-50. It means, like many here, there's still probably a fair bit of confusion, and we may need to go back over some of this material just to clarify it, because some of these questions, when asked without reading into the actual act or reading into the divisions, it's really hard to pull out what the correct answer would be.
Yeah, hopefully the tutorials would provide opportunities for better understanding, because then the tutorials as well will point you to what the proper cases or statutory provisions are relevant.
Yeah, I don't think Nicholas was criticising the tutorials, Manjo, not by any stretch. Okay. We all appreciated and enjoyed it.
Okay.
But it is a complex area. And yeah, like Nicholas, I normally get them right, but I didn't bat 50-50 tonight. Yeah. So maybe this is something I certainly need to go over. And if there's time and opportunity and you can schedule something, we'd be most grateful.
Okay, very good. Okay then. So thank you everyone for your active participation. And I'll see you again on Thursday, hopefully. Okay, see you soon. Bye.